Can anybody hear me?
Yes, I can. My name is Shri.
All right. Thanks for that. You always have that moment in the Zoom call at the very beginning where you wonder if you got zoomed. I think this is good. We'll get started. I know some more people will pop in, but I just want to start off by welcoming everyone. For those of you that don't know me, I think everyone does, but just in case, my name is Ismael Reyes, and I want to welcome you to this Greater Central Florida Multifamily Investor Group meeting. Mouthful. All right. In this group, like I mentioned, the idea is, focus on multifamily, and we focus on Central Florida, Greater Central Florida, because it extends quite a bit away from what some people would consider Central Florida, even the I-4 corridor per se. And the idea is, either you're looking to invest here, that's one, or you live in the area and you're looking to network with people that are investing elsewhere or here. So that's kind of the gist of what this is about, and I hope this is useful to you. All right, good. So let's go ahead and tee up this photo. So I'll give you guys a second in case you want to do your own capture on it. I see some people, getting pretty. I can't help that. I don't get any prettier. This is all I got. So we'll go with it. So, all right, if everyone's ready, we'll do 3, 2, 1. I got it. All right, good. So I'll post that probably tomorrow on LinkedIn and get you guys a little bit of additional exposure. Maybe even put some of the notes from today on there. So great. All right, we got it. Let me save this thing so I don't lose it. And then we will continue the show. Got it. Okay, perfect. All right, so now we got that out of the way. Let's go ahead and not waste any more time to get our guest speaker going. It is my pleasure to introduce Todd Robinson, attorney at law. Todd is a managing partner of Robinson Franzman Law. He serves clients across the U.S. as counsel for multifamily acquisitions and development, commercial real estate finance, private equity, financial services, commercial real estate development, and investment. Todd and I have had a chance to actually work together on some deals, so definitely love working with Todd, and I'm looking forward to what he has to say. Specifically, we're going to jump into some of the SEC regulations as they relate to real estate syndications, and we'll definitely have an opportunity to ask questions on this. And I'll leave it up to Todd if he wants to hold off to the end on the questions or do it as we go. So Todd, without further ado, I'll turn over the floor to you. I'm going to share right now so you can get your screen up.
Okay. Yeah. Thanks. Thanks, Ray. Like Ray said, my name is Todd Robinson. I'm based in Atlanta, Georgia, but we do work with clients all over the country and across the world. Actually, we've got some investors in Singapore and Israel and India and other places around the country that we and the world that we help in their commercial real estate transactions here locally, and also whether it's raising money completely in a foreign jurisdiction or bringing money over from foreign locations into the U.S., we can certainly assist with that. So, okay, let me see if I can share my screen here. Okay, can you guys see that? You see it, Ray?
Yeah, can definitely see it.
All right, we're good. Okay, perfect. All right. So we're going to talk a little bit about the SEC rules for real estate syndications. I realized when I was going through this presentation earlier, I've given this one a bunch of times. I've given it to Rod Cleef's group a bunch of times and some other networking opportunities. And it really dives into more of like what the operating agreement looks like in a syndicated real estate transaction, and kind of breaking down some of those terms that may not be familiar to passive investors of how does the operating agreement actually work, and how does the management work, and how are decisions made, and what are my rights as an LP or a GP, what do we do when we want to sell the property, that kind of those kind of topics. So I'm going to go through that, and then towards the end, I have some slides in there about specifically 506B or 506C transactions, and other SEC regulations that you need to be aware of. And as far as questions, I'm really comfortable. Ray, whatever when you shared the screen, I lost the chat, so I don't know where that is. Let's see here. So
what I can do is if anybody's got some questions and they
Yeah.
post it on the chat, I'll push those out. I'll ask them as kind of as we go.
Okay, let's do that. Yeah, and we can share this presentation definitely afterwards. There's a pretty picture of myself and just a little bio of the work that I've been doing. So happy to just take a look at that. All right, this first slide here is a deal we did recently, actually closed it 2 weeks ago. And this is your org chart. So this is when we're getting deals ready to submit to lenders, we have to prepare this document as part of our lending package and submit this to the lender so that the lender knows who are all the players, because they have their own anti-money laundering regulations they have to comply with, KYC regulations, know your client, fraud checks that they have to comply with. So they need to know who all the players are in the transaction. This particular, I took all the names out, but this particular deal actually ended up being a TIC transaction, if you guys understand what that is. So it's called a tenant in common transaction because one of the LPs was bringing in a substantial amount of money. He was bringing in almost $4 million, and he was actually syndicating his fund or his investors to bring into that deal. And because he was doing that, we learned that late in the game. It was a week before closing, 2 weeks before closing. He said, "Oh, by the way, I'm just coming in with one LLC, but all my guys are going to invest in my LLC." And I said, "Well, if you do that, then you're going to be subject to the Investment Advisors Act, and you're going to have to register as an investment advisor unless you can satisfy one of the exemptions." And he would have satisfied it as a small private fund investor. He would have still had to file a truncated Form ADV, but he would have gotten through the exemption just fine. But it was too late in the game to do that. So I made the decision as far as just structuring the transaction to say, well, why don't you just come in as a TIC? So what that means is you'll see here this Wyoming entity, ARC 4375 Cascade, is 51% TIC owner, and then 4375 Holdings is 49% TIC owner. This represents basically two syndicated transactions. One syndication was 4375 Holdings. The other syndication was ARC 4375 Cascade. And then within those two entities, you'll see here Class A members 50%, Class B members 50%, and then under ARC, the manager managed ARC Multifamily Group Fund 1 was 70%, and Class A members was 30%. Now, an interesting fact that I didn't know from this particular closing, this was a Fannie Mae loan assumption. It was a $20 million deal, and we were assuming an $11 million loan. And I'm kind of getting off in a tangent here, but it's interesting for anyone who's doing agency transactions, or you're doing a Fannie or a Freddie loan, you have to meet certain net worth and liquidity requirements. And it's typically the liquidity has to be in the amount of the loan. I'm sorry, liquidity is 10% of the loan. Net worth is typically the amount of the loan. Well, what I learned in this transaction was because this was a TIC transaction, Fannie requires that each individual TIC member meet the net worth and liquidity requirements. And I didn't know that. And so the investor who came in at ARC 4375 Cascade, he did not meet the net worth and liquidity requirements. So what we had to do is we had to make, you'll see this 0.01% member, Class D members, we had to make the owner of, or the manager of 4375 Holdings a member of this entity so that they could count his net worth and liquidity as a part of the other TIC entity. A lot of paper pushing for really the same result. They're all the same people, and so we kind of fought the lender at first about it, but they are, they have their rules, and so we had to comply with them. But just to give you guys an idea of what a kind of a more sophisticated, larger transaction looks like, and kind of what are the steps we had to go through. All right, so who are the members of the company? When it's a syndicated transaction, you typically have two classes of shares, Class A members and the Class B members. The Class A members are generally the limited partners who are bringing in the substantial amount of equity. The Class B member is usually the sponsor who found the deal and put the deal together, who's going to guarantee the loan and who's going to run the asset. And for that, they receive a promote or a sponsorship interest, which is typically held in a Class B share, but they don't actually. Sometimes they do put in their own equity, and sometimes they just raise equity from other LPs and LP investors, and all they're entitled to is the promote interest. The Class A members as LPs typically have no voting control, no management control of the entity. Now, all that kind of depends. If you're a sponsor of a deal and you're a new sponsor, you may want to structure your operating agreements in a way that that provides some voter control for the Class A members. And I see a lot of sponsors, newer sponsors doing that because they don't really have they don't have a track record. They don't have something that LPs can look at and say, okay, I know this guy is going to make a lot of money on this deal. I don't need to worry about it. And some other sophisticated investors will come up to you and say, I need to have some certain level of control. So this is certainly negotiated within the operating agreement.
Hey, Todd, I have one question that came up on the tick. The question is, it says the owner needs to have net worth and liquidity. Please confirm. I guess the individual has not heard. And if I got that wrong, please jump in, Julie.
I want to see if I can find the chat here. So the sponsor needs to have a net worth of at least the loan amount, and then a liquidity in the amount of 10% of the loan. And that's typically the requirements for bridge loans and for Fannie and Freddie loans.
Is that different for the tick slice of that, or is it the same?
Well, so what we found out in this last transaction was that in the tick entity, you basically have two owners of the real property. So the limited warranty deed is from the seller to tick 1 and tick 2 as owners of the property, as tenants in common, owning a percentage interest. So both of those entities actually own the real property, as opposed to selling the property to one entity, and in that entity you have investors within that entity. So in a tick transaction, yes, both tick owners have to satisfy, or tick managers have to satisfy the net worth and the liquidity requirements.
Thank you.
Yeah. All right, some other general but important provisions. Again, this is run-of-the-mill corporate stuff in your operating agreement. So depending on your level of sophistication with this stuff, it may just, stuff but other people don't necessarily know it. So what's the name of the company? It doesn't really matter unless you're trying to build a brand, and you want to. A lot of sponsors will name their entities for either the property address, or they have, they'll have their company name and they'll say, 1, 2, 3, and 4. But again, it doesn't really matter from the investment standpoint. What's the principal place of business? What's the jurisdiction? If you're going to receive a legal notice from the lender, where do they send that? Typically, I always get asked the question, well, Delaware is usually the best place to file incorporate companies. Delaware or Wyoming is a good one that people are doing these days. New Mexico, Nevada. And I've incorporated companies in all of those jurisdictions, but I have yet to make the argument or rely on the fact that I've filed in those jurisdictions that help my client. I think a lot of those, if there's I think Wyoming doesn't pay any state tax, state income tax. And so for those reasons, it makes sense maybe to file there. But so I think unless there's a tax reason, I've never actually had to take a litigation case, for instance, all the way through and said to myself, thank God I filed this company in Delaware because X, Y, and Z reason. I will say though, I'm handling a partnership dispute for one of my clients, and we had to hire local counsel in Delaware because the entity was formed in Delaware, and that was the agreed principal place of business. So it is a little bit more of a little more cumbersome if you have to go find counsel in another jurisdiction to get some papers served. Now, what's the purpose and nature of the business? I usually like to say all legal purposes, just because you don't want to run into any arguments that the company is set up and doing something that it's not permitted to do. How long is the company going to operate? What's the term? In real estate deals, it's typically just for as long as you hold the real estate. And then after you sell the real estate, there is a winding down period, six to 9 months, where you sell the asset, you pay your bills, you pay your taxes, or you keep some reserves for taxes, you pay your distributions to your investors, and then you can wind down the company and dissolve the company. Typically, entities are set up for the single purpose of owning that particular asset. And so they don't exist beyond the ownership. Representations and warranties of the members. Now, you as the sponsor, if you're looking to become a sponsor or a syndicator, these are important provisions for you to have within your operating agreements, because the members that sign on to your OA are bound by these reps and warranties. If you were ever to get into any dispute down the road, and most investors don't read this stuff, and that's typically how a lot of the, we of course read them with a fine-tooth comb, but a lot of investors don't read this stuff, and so the ones that do and have questions, I'm always happy to answer them, because I appreciate that. I think it's a good business practice. But you're going to be making sure they rep and warrant that they understand this securities offering is not registered with the SEC. This is a private offering. This is why we're relying on Regulation D of the Securities Act, and it's called a private placement for that reason. There's no public market. There's no third-party beneficiaries. You have to make sure the investors that you're bringing into transactions are not purchasing those interests with the aim of trying to sell those interests at a later date. Whether they've received any advertising, if it's a 506B transaction or general solicitation, you are not allowed to solicit to the general public any of your private offerings. That is a rule that the SEC struck when they created 506C, which does allow general solicitations, but your investors can only be accredited investors, which we'll talk about that in a little bit. But you're going to have a rep and warranty in your operating agreement if it's a 506B offering for them to specifically state they have not received any solicitation. I found the chat. I'm just looking at the chat now. Now, Ray, I can go into some of this if you want to.
Yeah, no, if you want, I think the tick piece, part of it may have been that, the sound was a little bit off at the very beginning. So there may have been some people that didn't quite hear, but there's a lot of interest on the tick structure. And I know that is an interesting topic, and it's not one that your average syndicator jumps into or is involved in. I know there's a piece there where, potentially somebody with a 1031 can possibly use that tick structure to jump into a deal where they normally you wouldn't be able to do that.
Yeah, and it's good. It's a good tool if you are partnering with other sponsors and you're trying to take down a deal yourself, and you don't want to get into a fund of fund situations where you have to deal with the Investment Advisor Act. So the tick transaction, but to answer your question, yes, ticks are a little bit, it's a little bit trickier than just being a GP, because what happens is you have the tick and you have two entities, and then you have what's called a tenant in common agreement, a memorandum of the tick. And that tick agreement details the roles and responsibilities of each partner. And it says in there specifically, like the tick we did, that all of the cash that's going to flow through the company is going to be governed by 4375 Holdings operating agreement, of which tick number 2 is a member. So they're a member of the syndicated entity agreement, but then they're also an owner of the real property, because the limited warranty deed is being transferred into their name. So they actually own a percentage interest in the real dirt. So, and there's even another layer that's a little bit more complicated. We prepare what's called a commission agreement, and it's really a document that you provide. It details the services that the sponsor is providing to the TIC entity, and in exchange, the TIC entity is agreeing to pay them their percentage interest of the acquisition fee, and is also agreeing to receive cash distributions pursuant to the operating agreement of the original sponsor versus pursuant to the TIC agreement, because the TIC agreement says if you own 51% and the other TIC entity owns 49%, then the cash is distributed 51-49. Well, that's not how we actually are going to distribute the cash. We're going to distribute it based on the operating agreement, which says, whatever the waterfall is for the distribution, or if it's 70-30 split and a pref, that's how it's going to be distributed versus the actual TIC agreement. And I can share some of these documents at a later date if people are still interested in it. Okay, sorry, getting back on a tangent here. So again, more reps and warranties of the members. You want to make sure they're obviously comply with anti-terrorism laws. They haven't dealt with any terrorists. They're complying with Executive Order 13224. Now, what are the initial capital contributions of the manager and of the members? So what's your raise? Is your raise $2 million? Is it $1 million? Is it $500,000? You got to figure out what your raise is going to be. And then you got to figure out what your units are going to be. If you're going to raise, if it's going to be a minimum of $50,000, $20,000, whatever the minimum is, the SEC doesn't care. It's just whatever it is, you got to make sure you're consistent and make sure you accurately disclose that to your investors. But you need to do that calculation on the front end and figure out how many units you're going to be selling. The Class B member, that's usually the manager and or the sponsor. It's typically a nominal amount of units, and again, the units that a sponsor has in their entity are not reflective of the actual cash contribution. Whereas in Class A members, their units are reflective of their cash contribution. The Class B member units are really only a representation of the manager's promote. So what's the manager's profit interest in the entity? What are the subsequent capital contribution requirements? Now, no one likes to think about this, but deals sometimes go south and you may need additional capital from your investors. How do you handle that? What does your operating agreement say? This is a provision that you should look at very closely. I have clients that will never go to their LPs for any additional capital whatsoever because they think that somehow negatively impacts their standing as an investor. I've got other clients that will say, no, if more capital is needed, then the LPs have to fund it. So it just it depends on what your risk tolerance is and what your level of comfort is with your investors. If the LPs don't fund though, and you have to go out and sell more LP interest, then the original LPs are going to be subject to dilution. Whereas if your raise was $1 million and you had 10 LPs at 100 apiece, now you've got 20 LPs. Those are going to be worth less. So the LPs are going to have to know that if you have to go out and sell more interests. Again, a lot of this is the manager's discretion. We'll find that later in the management section. Instead of investing more money, you can also take a loan from a member. You can take a loan from an LP, or the GP could loan money to the entity, and then book that on their books as a member loan to the company. Lots of options, and in this particular market, there's not a lot of, in my experience, there's not a lot of heavy value add going on where sponsors are running into cash flow problems because they've got 200 unit complex and 150 units are down and they're trying to do a huge construction project to get them all back online. We've been through those deals, in the near passed, but I think most of those have been picked through and been renovated and been sold again. And I haven't seen a lot of those out there lately based on my experience. But those are situations where you need to watch very closely what are your subsequent capital contributions. What is the capital account? Now this is going to be something that your accountant is going to be more concerned with than your lawyer. But a capital account is basically an accounting tool to keep track of your equity stake in the company. So if you've invested $100,000, then your capital account is $100,000. If you've received some preferred returns, then your capital account is going to go down based on that. If you've contributed some services to the entity, then you could consider that as a contribution that would be worth some amount of money in dollars, and you could increase your capital account by that amount. Again, most of this is going to be discussions with your CPA. When an investor invests money into the entity, there's typically not going to be any withdrawals. You can't, once you're invested until the property sells, and you're going to get your money back and get your return. There are situations where you can request your money back or request money out of the company, but it's going to be, again, at the manager's discretion. There's no interest paid or any capital other than per the agreement. Now, there's no obligation to restore a deficient capital account. I've got one client that does have I think it's called a DRO obligation, which is an obligation to restore a deficient capital account. I don't know too much about that. I just know he likes that in his operating agreements, and I've talked to his accountant about it. Now, we talked earlier about member loans. Your member loans they do bear interest. There's no additional ownership, and it's going to be repaid in accordance with the distribution schedule. Typically, the distribution schedule will have member loans paid back before the equity is paid. And Rob asked a question about. Yeah, sorry. I guess I was confused. I wasn't saying it would be. He asked the question, why would your capital account go down with payment of preferred returns? That was a mistake on my part. It would be paid if you were getting some of your capital back, not necessarily your preferred return on your capital. So that was a slip up of mine. Okay, so distributions. How is the cash going to be distributed within the operating agreement? And again, if you're an investor thinking about these investment opportunities, this is going to be a provision that you're going to want to pay close attention to, and you're going to want to decide if you're comfortable with it or not. Typically, there's going to be a preferred return, which means that is usually either a monthly or quarterly amount of money that's distributed to you based on the amount of capital that you put in. So if you put in $100,000 investment and it's an 8% preferred return, you would typically receive $8,000 a year on that $100,000 that you've invested. And most sponsors will return that or pay that preferred return every quarter. So if you invested 100, you would be getting $2,000 per quarter until there was a capital event. And the capital event's either a refinance or a sale. And what this slide basically says is that's how it's governed. So first it's to pay the preferred return, and then thereafter it's split 60-40. This is a very simple distribution schedule. 60-40 split, preferred return up front. The Class A members, the investors, the LPs, are getting the majority of the profit share on the back end at 60%. The Class B members are getting 40%. Right, so this is just looking more on if there's a sale, the initial capital is returned first until that capital account is reduced to zero. So we talked earlier about capital account. If you had a $100,000 capital account and there's a big sale, you get that $100,000 back first. Then you would there's usually an accrual of the preferred return. So some properties may not be able to pay the preferred return each quarter if they're going through a lease up period, if they're going through a value add period where they're having tenancy issues or there's just not enough cash flow available. that preferred return would still accrue over that time period. And so that would get paid at next. And then after that would come the split. This is a scenario where there's more of a waterfall to the distribution. And a waterfall is just a term of art, but it basically just means, I don't know who came up with it, but it means that the cash flow will adjust based on a certain metric. In this instance, it's based on the internal rate of return. And so this is from one of our operating agreements, but there's subject, first you're gonna pay the manager its management fee. Manager always has to get paid first. After that, the Class A members are gonna get a pref of 8%. And then once that 8% pref achieves an internal rate of return of 8%, now that's a different metric. Getting a pref and then achieving an IRR of 8% is a different metric. Then, in addition to receiving that 8%, any additional cash flows at that point are going to be split 75-25. Now, after that 75-25 split, the IRR is still being calculated, and you've got more preferred returns being distributed. That increases your IRR. Once the IRR reaches 12% in this instance, then in addition to receiving those 8% for preferred returns, your split goes from 75-25 to 65-35. And that's pretty typical. And I've even seen up to 14%, 50-50. And again, a lot of that just depends on your level of experience, your sophistication. I represent Rod Cleef and his group in a lot of their deals in Georgia, and they are, they've got such a good reputation with investors that they just offer a pref and then they offer a 50-50 split of profit at the end. They don't even have to go through a waterfall because they know they've got that much demand. All right, when we're terminating a company, we talked about this earlier, we're going to pay the outstanding debt, we're going to set up the reserves for any unseen liabilities, we're going to repay the member loans. If there was a subsequent capital call, that's going to be paid back upon termination of the company. Then we're going to make our distributions to the partners. Admission of additional members, typically not permitted without the manager's consent. And it leads us into how is the LLC managed? Again, all the decisions of the company are made by the managers. And so it's very important, if you're an LP investor, to really vet those managers, to understand that they have experience, they understand what they're doing, and they are going to do a good job and make you a lot of money, because they can do anything under the sun. Class A members, again, we talked about this earlier, no management responsibilities, no control over the company. You want to have a good understanding of who the team is, who the sponsorship team is before you invest. Now, what if the manager is committing fraud or stealing from the company or mismanaging the asset or, just not doing their job and not doing a good job and losing money? How, as LP investors, how do you protect yourself? Well, there's usually a removal provision in the operating agreement. And there's very strict ones that are very favorable to the manager, and there's ones that are very favorable to the LPs. This first one is obviously ironclad, very favorable to the manager. You'll see you can only remove the manager upon final adjudication of a court of competent jurisdiction. So that means all of the LPs, or one LP, I guess, would have to file a lawsuit in court to remove the manager, go through the whole litigation process, waste 6 months to a year, win, and then the manager gets removed. So again, if I'm representing sponsors, that's my provision that I put in the entities usually. If I'm representing an LP investor that wants me to look over their documents, I'm going to look at that provision to see how that's drafted. There's also, with a vote of a supermajority of Class A investors, this is where Class A investors have a bit of power. It could be 80%, it could be 75%, but if if the LP investors get enough, get together and they have enough interest in removing the manager, there is a process for removing the managers. Let's see, there was a question, what are examples of reasonable removal provisions to slightly sponsor favored? I would say the super majority is kind of the middle of the road, where that still favors the sponsor because you're going to have a super majority, and that could be 90%, and you can make that super majority whatever you want, more than 51%, obviously, but the more percentage that you have, the more favorable it is to the sponsor, but you're still giving the LPs a bit of control. Now, if you're entering into a JV agreement with institutional investors, we have a lot of family offices and institutional clients. That's a whole other ballgame. The operating agreement that you'll enter into with the JV partner is going to look a lot different, or at least with a private equity group. They're going to have a lot of discretion to remove the manager if they feel like it's not going well. Usually fraud, willful misconduct, gross negligence, breach of the agreement. There could be budgetary provisions. We had a huge $30 million value add deal in Texas we were working on, and there was a multifamily private equity fund that was putting in $6 or $7 million, and it was a $10 million construction project, and they had very strict budgetary guidelines, and if you miss that budget, you're out. So they had a lot of control. Compensation of the manager. Now, the manager is usually entitled to an acquisition fee. That's how sponsors usually live deal to deal on their acquisition fee. There's usually an asset management fee, 1 to 2%, and the fees are obviously in addition to distributions. Now, if you're working with a lender, at least a sophisticated multifamily lender, they're going to redline your operating agreement, and they're going to make sure that any fees paid to the manager are subordinate to their payment of their note. So just things like that we often look for when we're negotiating documents with lenders counsel. We talked about it earlier. Admission of additional members must have prior written consent. The assignment by members. Typically, members cannot assign their interest in the entity to another investor. There are exceptions, of course. There's always exceptions with the manager's consent, and you can typically transfer it for estate planning purposes. And there's other instances where you can do it. I mean, I think under Rule 147, you have to, after a year, you can transfer your interest to another investor, and then you have to figure out how to value that interest. And there's a valuation process that's typically set up within the operating agreement. In addition to value, let's see, where am I? Okay, yeah, that's just valuation, how to value it. There's a question here. Do any of those fees get paid to the TIC? Yes. So in my deal that we closed last week, the TIC brought in like half the equity. I think it was a $7 million raise, and they brought in 3.7, so a little bit more than half. And they got about half of the acquisition fee. I don't think they're not going to get the asset management fee, because the sponsor who's running the day-to-day, this particular sponsor had their own property management company as well, so they're running the asset. They'll be in charge. They'll be entitled to their own asset management fee. But yes, the TIC entity would be entitled to the acquisition fee. But again, I say that it's all negotiable. If you could say to the TIC, yeah, you can come in as a TIC, but I'm not going to pay you the acquisition fee. It's all going to go to me, and you just have to document that in your operating agreement. How are we doing on time, Ray? I'm at 33 minutes. We okay?
Yeah, we're good. If some people have to punch, they have to punch, but we'll keep rolling. You got all night with me.
All right. What are drag along rights and tag along rights? These are corporate concepts that come up in operating agreements. It's really when a majority of the members want to approve the sale of the membership interest, it would be a drag along. You're dragging all the other members into the sale. Again, that's going to be the manager's discretion. If you're looking with doing deals with institutional capital, a lot of those are based on private equity funds, and funds have sunset terms where the term of the fund ends and they have to sell all their assets in order to close out the fund. If they do that, then they can force you to sell the property so that they can meet their fund expectations and guidelines. So one other thing I would mention here is the drop and swap. I don't know if anyone's heard of that term, but if you have any, so it's kind of the flip side of a 1031 exchange. So if somebody sold a property and they put their money with a qualified intermediary and they've got money sitting, they've got, I think, 45 days to identify a new property and then 180 days to close on the property. If you have an investor that is invested in one of your deals and you're getting ready to sell it, obviously they can't qualify for any 1031 because they don't directly own the property. But what we've done in the past is what's called a drop and swap, which means you have, 123 Main Street, and then you have investor A has put in $500,000 into 123 Main Street. Well, when you get ready to sell the property, 123 Main Street will quit claim, say a 5% interest, whatever the valuation comes up to be, but quit claims a 5% interest to investor A. Then 123 Main Street and investor A both transfer their interest into the new buyer. And by doing that, investor A therefore meets the 1031 requirements and can receive their percentage interest in return for their 5%, and then that money can go directly to a qualified intermediary. So it's a little bit more work as a seller with your selling assets to do that, but I always recommend if you have any big investors or cornerstone investors that are putting in, 500,000 or more, then it's a good thing to offer to those investors. All right, disqualifying events. These are just, these are events that would disqualify certain investors from taking part in any Reg D offerings, certain criminal convictions, SEC disciplinary orders. A lot of that I've never had to see this, but it's something to be aware of. Calculating preferred returns. How do you calculate a preferred return? Is it compounded or is it non-compounded? So compounded means the calculation of the preferred returns periodic growth amount comes from the amount of invested capital plus all previously earned but unpaid amounts. Is it cumulative or non-cumulative? Cumulative means that the money earned in one period that is not paid out at the end of that period are carried forward to the following period. And how much is it? What is the measure of the preferred return? It's usually based on the amount of capital that is invested, and typically it's non-compounded. This is an interesting slide because I've got a lot of questions on what's the difference between preferred returns and preferred equity. The preferred return is a preference on the return of its capital. Return on the capital. So you get is a preference in your return on your capital. The true preferred equity is the return of the capital. So in the disposition of an asset, a preferred equity investor is going to get their capital back first before everyone else gets their money, versus a preferred return is going to get the return on their capital back first. All right, so this is just going over some typical 506 B or C regulations for the SEC. So is it a security? I always get this question. Well, do I have to comply with Reg D or not? What's the requirement? Well, is it a security is the first question. If it's not a security, then no, you don't have to comply with the SEC, and you can just enter into a typical operating agreement with your buddies to go out and buy property and not have to worry about syndication. If it's member managed, then typically that is not a syndicated entity. So if you have 10 investors and you guys all want to put in $100,000 and you're all going to be, it's going to be a member managed entity. You're going to nominate one person to be the managing member, but then everyone else gets, certain voting rights. And that's just a joint venture. That's not a syndicated entity that you got to worry about complying with Reg D. Most, if not all, syndicated transactions are manager managed entities. And that's where that's the security world. You have to comply with the SEC regulations, where you have LP passive investors that are, and the manager is making money solely on its efforts to manage the asset, sell the asset at a higher price, make money, and then get paid. That's going to be a security transaction. And then with large public offerings, you don't have to worry about that. But then are you exempt from registration? And this is where Reg D comes into place. Is it a 506B or 506C transaction? Well, what are the differences? If it's a 506B, then neither of them have any limits on the amount raised. But the 506B, you can have an unlimited amount of accredited investors. The accredited investors may self-certify. Typically, our subscription agreements have an investor questionnaire at the end that you have to fill out. And then you have discharged your duty as a sponsor in certifying that these are either accredited or sophisticated investors. The PPM is obviously recommended, if not required in those instances. You are not allowed to advertise your offering. So you can't do public webinars. You can't hold meetings or meetups where everyone in the room is not known to you already. Again, a lot of this is very gray. There's been circuit court cases that have dealt with this issue that we've looked into. There's no action letters from the SEC. There's a lot of gray area as to, well, how long did you have to know them for before you could ask them to invest, and how friendly do you have to be? I mean, generally the rule is if they're friends and family already known to you prior to the deal coming to you, then that is someone that you can solicit an investment into this transaction under 506B. Under 506C, you can only have accredited investors. The sponsor has to be reasonably assured that there are accredited investors. Now, what that usually means for 506C transactions is that you have to go one step further and have them provide evidence of their accreditation status. Usually that's a letter or a letter from their CPA or their lawyer or their investment advisor stating what their net worth is or stating what their salary is, so that you can comply with the accreditation requirements. PPM is recommended, of course, in both instances, but not necessarily required. Now, advertising is allowed in this instance. So if you're going to do a 506C offering, you found a great deal, you want to offer it to the general public on Facebook or LinkedIn, or you want to hold a meetup and invite everyone that you ever could possibly know, you can do that under 506C. You just make sure you comply with the other requirements. What is an accredited investor? Generally speaking, net worth in excess of $1 million, excluding their primary residence. So taking the primary residence out of the value of the primary residence, or an annual income of $200,000 or $300,000 if filing together. Now, also entities net worth of $5 million or more would typically be satisfactory to qualify as an accredited investor. Now, what needs to be in your PPM? All of this needs to be in your PPM: description of the business, dispute resolution, liquidity, voting rights, property information, distribution and fees, sources and uses, suitability standards, conflict of interest, risks, offering terms. I mean, the PPMs, you guys have probably seen them. PPMs are typically, 40 to 50 pages long. They're really there to cover your ass. I mean, it's a CYA document. It's a document that describes the opportunity to the investor and puts all of the disclosures out there that that could ever come up under the sun So that if something goes wrong, the investor says, you never told me about this. You never told me that we could lose money or that the economy could tank or whatever happens. Yes, I did. Here's the PPM, and you decided to invest anyway. Let's see. This is the last slide. It's just kind of an interesting take, something that I get questions about, and it's just an interesting topic. I feel like what's the difference between a true return versus a pari passu preferred return. Pari passu is a Latin phrase meaning of equal footing. You'll see that term in operating agreements quite a bit. If an investor receives a preferred return before that means they're getting their return before the sponsor does, then that is a true preferred return. Most syndicated transactions are true preferred return where you're getting the LPs are getting their money before the sponsor does. However, if they get the return at the same time, then that's a pari passu return. And again, it's just semantics. So if you're looking at an operating agreement and you see it says the returns are pari passu, now well that means I'm getting paid at the same time the sponsor is. I thought I was getting a preferred return. What's the difference? And that is it, my friends. That's my contact information. Like I said, I'm happy to answer any questions. You guys have my contact info. Please feel free to reach out at any time. Generally always available and happy to answer any questions now or later.
Todd, I have a question for you. What in your estimate or based on your experience, what's the thing that throws off most syndications? The error that gets the majority that, of course, you're hopefully there to catch, make sure they do it right. But that'd be, I think, a good point for this group.
Yeah. Well, throws it off from from a deal perspective or
potentially, think of a fruit of the poison tree when they do something wrong that the syndication can then be in some sort of jeopardy.
Well, I think, if you were to lose your exemption from the SEC, then that would obviously be a really big deal. Because how we do this is once we usually raise all the equity in a trust account. Typically, I act as the trustee, and my clients will wire their money to my trust account. I'll hold the money until we're ready to close. I also have, we act as escrow and settlement agents for these transactions as well. I'm a title agent for Chicago Title, so we handle the title work, and we'll do all of the nuts and bolts of the actual closings. And, from that time period from when you close, there's a 15-day window when you have to file what's called a Form D with the SEC. And that's a document that just notifies them of the transaction. And again, it's a private offering, but you don't have to register like a public offering, but you have to at least notify them. And so, if you were to get, lose money, rule number one of investing, never lose anyone else's money. If you were to lose anyone's money and then they come back and they want to file a complaint with the SEC and they open up an investigation and they find out you did something wrong, it was a 506C and you were or B and you were advertising, you could lose your exemption. And if you lose your exemption, I'm not sure what the penalties are. I'm sure there's some sort of penalties, maybe some disgorgement that would happen, but that would be the ultimate bad thing, I guess you could say.
One thing I've heard with regards to the JV is that sometimes they do something wrong and it stops being a JV and becomes a security. What is it that causes that? Is it because it's a member managed, but yet there's one member that all they did is put capital in, or what is it that kind of throws it into the securities?
Yeah. So well, that's a good question. So a lot of times sponsors will group together to take down a deal. And if you've got 4 or 5 sponsors, and all of those sponsors are going to be members of the GP entity. We call it, that there's the entity where all the LPs are going to invest in, but then there's the sponsor entity where you have 2 or 3 members that are going to be the GPs. Well, if those members, if one of those guys is a member and all he did was raise money for the acquisition, you could get into some trouble where they're getting paid for raising equity. And that's not necessarily a syndication problem. That's what it is, but it's more of a broker dealer problem, because you can't raise equity without being a licensed broker dealer. And so what we've come up with in those instances, when we have multiple sponsors, is we execute what's called a co-sponsorship agreement. And in that agreement, we actually list out all of the roles and responsibilities that each member of the sponsorship team has. If Reyes doing investor relations and Yanu's doing asset management, and someone else is doing lender relations, working with the lender, it's all combined. And usually that document is signed, we put it in a drawer, and we never look at it again. But if the SEC ever came, or anyone came and said, you got paid for raising equity, you violated FINRA regulations, then we would pull out that document and say, no, we didn't. Here's our co-sponsorship agreement. So Peter asked if there's changes going on with the SEC and fundraising. There are. I know that they have made it easier to raise funds, but from my reading, and I haven't read in it in too much detail yet, but I think it has to do mainly with almost like IPOs being private. Like you can raise money for an IPO privately versus a public offering, but I don't know too much about that piece of it. There were some changes. I was actually looking at it before the call. There are some additional definitions of what an accredited investor is, and they've relaxed some of those rules on certifying that information. But I've asked one of my associates to do a write-up on it and haven't received it yet. So we're still waiting on that. Peter, have you been reading more about that?
No, I just started hearing about it, like a week ago.
Okay.
I'm waiting on you guys.
Yeah.
It's not like, a pressing issue for me. So I'm not, but it's, hopefully it's positive.
Yeah. They're looking at ways of like simplifying the exemption framework. I mean, it's all very complicated. But no, we're keeping an eye on it, and we should have some white papers going out in the next couple weeks about it.
So if I want to get on your white paper list, should I just email you or go to your website or something?
Absolutely. Yep.
All right.
This is Vinky. I have one question for Todd, and I'm not sure. I was a little bit I was not 100% in your presentation, but I'm not sure if you have already covered it. Please excuse me if you already covered it, but I wanted to ask, because my understanding is when you're coming in as an LP or a GP in a deal, or you're going into the multiple deals, and somebody was telling me the best way to do is each time when you're going as an LP or GP, you should have a separate LLC for that. So I wanted to ask you a question about that. Is that a true statement? Even if you're going as a GP and LP in the same deal, you need to have two different LLCs? How does that work?
Yeah, good question. I mean, I think it just depends on your appetite for risk and the structure of the deal. If you're the sponsor and you're putting the deal together, then you're going to typically create a separate LLC. That would be like what we call an SPV, a single purpose vehicle for the acquisition of that asset. Now, the member of that GP entity could be if you have a holding company that you have all your real estate interests in, you can hold multiple interests in multiple GP entities with one single entity, if that makes sense. And if you're an LP, a lot of investors invest just in their own personal name. You can invest your LP interest through a pass-through entity. There's no real benefit from a tax perspective because it's a pass-through entity. So as an LP, I wouldn't be, you can, if you're, Investment LLC is the name of your LP entity. You can have Investment LLP in multiple deals as the LP. Now, I don't really see a problem with that. I mean, they're not, LPs are not really, they're not subject to any liability if something were to go wrong, because they have no management, oversight, control. It's a complete passive investment vehicle. So I wouldn't be worried from a liability perspective, so that you have to create a different entity for each LP interest that you take. What people typically do is they have one entity that they'll use for all of their GP interests. But again, you still create a separate acquisition vehicle that you would use.
So what I'm hearing is, correct me if I'm wrong, as an LP, I can invest in multiple deals with the same LLC that I got, whatever my parent LLC is, but I should not commingle with that with my GP structure. If I'm going in as a GP in some deal, I should have a separate LLC because that way, from the liability point of view, it's like a better structure that way. And also, I'm going to ask a follow-up question to that. If I'm investing as an LP for my 401k and my regular savings, that's going to be two separate entities, right? Two separate LLCs. I should not just put them together as well.
Right. Well, your 401k investment would come from the trustee of your, whoever the trustee is of your plan, your 401k plan. I guess if it's a self-directed IRA, self-directed, then you would, but it depends on how that investment comes over. We've done it in the past where, even self-directed IRAs have a trustee of the plan. And so the actual investor would be the trustee on behalf of whoever the 401k is listed in. But then that would be one LP interest. And then you would have a separate one. If it was coming from your cash savings, it would just be yourself individually, or you'd have to put that money in an LLC and then invest it through the LLC.
To the LLC, okay. And then one should be good enough. I can have multiple investments.
Right. Yeah.
Okay. Perfect. Thank you so much. Thank you.
Absolutely.
All right. Good stuff. I think this is probably a good time. I'll definitely send this out. I saw some questions. I'll just, when I send it out to the attendees, I'll make sure I attach the actual presentation and link to the video. So we'll get that. Todd, that was fantastic. It answered a couple of questions that I had for sure.
Thank you.
All right. So I'm going to stop the sharing here, and then we will finish out here with some announcements. And then if anybody wants to stick around for some networking, we can definitely do that as well. I think, did we kick off the sharing?
Yeah, I stopped it.
Okay, perfect. All right. So first thing on the announcements, the next meetup that I have is going to be on the 16th of November at 8 p.m. We're going to have an international tax professional and attorney who's going to talk about foreign investors and how that, how you can kind of navigate that. Because I know that's definitely of interest to me as I look to, broaden my pool of investors. And I'm sure it'll be interesting to those that are either have some foreign investors and they're having to navigate through the syndication process. There may be some differences, and those that are looking to raise capital from them. So those are the two. So we'll get that. I'll get that out to the group and more on that later. And then I guess, and I do want to mention, I know Hutch, we can kind of start off the next thing as far as plugs. I know Hutch, you have Hutch and Heath, you guys have I guess a meetup on every other Monday, right? So if you want to talk a little bit about that real quick.
Yeah, I guess Hutch isn't there. So yeah, so the first Monday of every month, we have the Southeast Multifamily Investor Meetup. And we've gone to a new format where we have a meeting space, we have someone come and present, and then we have networking afterwards. Then all the subsequent Mondays, like the second and fourth Monday, it's just like this. There's no big formal, it's just networking. It's just nitty gritty. If you just like you were saying earlier today, like if you got a deal that you want to talk about or get some feedback on, if you have capital you're looking to place into a deal, if you're wanting to know property management companies in certain markets in the Southeast, if you need to know brokers and want to get the skinny on which brokers have been helpful and which ones aren't. Little things like that. Like this is just real nitty gritty stuff. So those are the second and fourth weeks. And then the third week, we all come to the Central Florida meetup.
Excellent. Excellent. Great. I know you guys are doing good things, and that's, I tell you, some of the areas you're investing are also interesting to me. Certainly, there's some areas, it was in Alabama that
Roll Tide.
yeah, that are interesting as well. So even us Florida folk like to look north every once in a while and see what's around. So that's good. All right, good. Anybody else have anything they want to plug?
Well,
This
I
is
just
the
wanted to
time.
say that Ray and Hutch and Heath, you guys been doing awesome job bringing everybody together. This starting a new venture, and I think this is a good networking session and very informative. And I would like to say thanks to Todd as well for bringing in so much knowledge to everybody.
Thank you.
Excellent. Okay, so I guess that does it. There's nobody else that's chimed in here.
No, this information was right on time. Yeah, actually had an investor contact me yesterday about investing in the deal that we have for as a GP with doing a 1031 exchange. So I gotta go back and watch the video and dissect it and make sure I can speak to her intelligently. Yeah, so this information is right on time.
Yeah. So if they have 1031 money, then the only way
Right.
to invest is through a TIC transaction.
Correct, that I'm aware of. But now are they automatically a GP, and do they get a acquisition fee and all that good stuff?
They're not really even in the GP LP entity. You know, if you have a GP LP entity,
Right.
that's
Okay.
they're over here, you know, in a separate transaction structure as a TIC.
Gotcha.
But you could still count their investment as an LP interest. They would just have to be on title.
Got you. And we do not have to pay them an acquisition fee. That's negotiable, right?
Oh yeah. No, you can say we can accept your LP interest. We'll accept your money as an LP interest, but we'll have to put you on the deed, and we'll have to enter into a TIC agreement. And within that agreement, we'll state specifically that their money is going to be invested as an LP interest, and that we would have a commission agreement between the two entities that would lay out the relationship and how the money that they invest, they're basically going to be paying you for the services, which comes in the form of the acquisition fee.
Okay.
I guess the toughest thing with that is just syncing the 1031 exchange with the acquisition. That seems to be always the hardest thing. I don't know if there's any strategies to that.
Yeah, they're still an LP they're still an LP investor. They're just coming in. I mean, there are some risks associated with it, obviously, because they're actually on title. And if they're on title, they're going to be a part of they will likely have to be a part of the loan. I've done TIC transactions where the TIC entity is not a guarantor, but if their interest is, if it's a small amount, then usually the lenders are fine with it. But if it's a larger, if it gets over 20%, then they're probably going to want that person to be on the loan.
Yeah, that was my question on.
Makes sense.
On a small amount, you can just do a carve out for the 1031s, right? If it's like a 5% of the amount or 10% at most, or under 10.
Right. So they could still be on the deed, and they would have to be on the deed in order to satisfy the tenant in common arrangements. And then, so they would still be on the deed. And then if it's usually under 20%, lender's not going to require them to be a guarantor.
Okay. No, all this information is timely, especially the org chart, because we're under contract. So up next is all the attorney syndication paperwork.
Oh, good.
So it'd be fun.
Yeah.
Due diligence first, though.
Congratulations, Rob. There you
Thanks.
go. There's a success right there. All right, last chance for any other plugs or successes. And then if anybody wants to stick around to chat a little bit more, I'm happy to stay as long as you guys are. Anybody else? All right. Well, I guess that ends the formal pieces of this, Todd. Again, thank you very much for the overtime on this one. It's a good thing you're not
Great.
on consultation for this.
No, absolutely. I get a lot of satisfaction out of doing, I do deals myself even, I've got some GP interest with some other sponsors, and I love this stuff as much as you guys do. So it's
Awesome.
fun to talk about it.
Awesome. Well, thanks again. I appreciate it.